And thank you. So, Your Honor, I'm objecting to a wholesale playing except for what the court redacted from Mr. Zachary's August 5, 2017, 2015 video audio recording interrogation. And there's Georgia cases that I have at my fingertips as well. But the first one is L as in laughter, K as in kitten, L as in laughter versus Ellington, Ellington. Your Honor, it's 2018 United States District Court, Lexus numbers 208774, decided December 10th, 2018. And in that case, the district court wrote that the trial court ruled that because AL's statement during it's CAC, but Child Advocacy Center interview were hearsay, and the prosecution had not introduced the interview, counsel could only introduce those portions of the interview where AL made an inconsistent statement, not the entire interview. And that's what I'm saying. Here the state, and I raised this at your bench 3 times. I said what I foresee is that the state is not introducing the interrogation, either one, there were 2. They're going to not use Mr. Zachary, and they're going to put it up with another witness, and you said, we'll see what happens. We'll see what happens in the future. Well, that's exactly how it played out, and it is my opinion that if there are true then I understand that. And it comes in under 24-801 D1A, because it would not be hearsay, because it would relate back to OCGA 24-6-613, prior inconsistent statement. But the state does not have a Kenneth Copeland where he would just say, yeah, I don't remember if I said it, but I lied. They have Mr. Zachary saying, I said that. I am a liar, but I said that. And that's different than the just, I'm a liar, I don't remember, I don't recall. So unless the state can go piece by piece on what is an inconsistent statement, I'm objecting to just having a trial by prior recordings. The state then puts it on the accused and said that, well, we objected to it taking so long, to the state going through the entire interview. The state was asking about, how old are you? Do you have a brother? Where do you live? I mean, all this just page by page, but they did not hit the specific statements that are now deemed inconsistent statements, and I'm objecting to the wholesale playing of a recording and the witness is gone. That's my objection. I have the Georgia case too, and that is Gibbs, GIBBS versus State 340, Georgia Appeal 723. It's in Division 2A, as in Elisa, 2017 case.
All right, thank you. Ms. Love.
Your Honor, I believe that the court accurately surmised that the testimony of Quindarius Zachary was given the way that he testified and what he testified to, much like with other witnesses in this case, he has set up where he has denied with the state information that he gave in the interview. He has claimed to not recall information that he gave in the interview. He has claimed to have lied about specific information that he gave in the interview, even to the extent that when asked identical questions by opposing counsel, he would give a completely inconsistent answer to opposing counsel. For instance, do you know this person? To me, he would say, I can't recall. 5 minutes later, to Mr. Steele, he might say, yes. Or to me, he would say, I can't read. 5 minutes later, he's reading a book placed in his hand. So Your Honor, I think that the court had it right. I would ask that the court allow us to present to the jury this pertinent information and relevant evidence.
All right. Yes.
I just respond. The part I disagree with is the state has already presented this evidence. When he's asked, did you say Shannon confessed? And he says, yes, I did tell the police that, but that was a lie. They've gotten that information out. He has confirmed that he told the police that back in 2015. And that's the whole point of using extrinsic evidence, as I understand it. The whole point of using extrinsic statements or prior statements to prove the point. It's when the person's denying it and you have to bring in that statement. I'm sure if we look at the transcript, there are going to be a few times, especially towards the end of, I believe, the second day where Mr. Zachary was frustrated and got into I don't recall mode. But other than that, he acknowledged what he allegedly said and said it was a lie, and this is why I lied. And I don't believe that lays the foundation for what the state wants to do.
Okay. So I think that by and large, he said a whole lot of I don't remembers and a fair bit of, if I said that, I don't remember saying it, but if I did, I lied, to the extent that the statement itself can come in as substantive evidence as a prior inconsistent statement. And if the defense has particular parts of the statement that you believe that actually were sufficiently handled such that the extrinsic evidence of that shouldn't come in, then please let me know. But I think by and large, it can come in, subject to the redactions, of course.
Can I respond to your request? He certainly acknowledged making statements about Mr. Stillwell allegedly confessing in both statements. And the reason I can remember that is because I went through them and talked about how they differed. But that was standard impeachment comparing two statements, but at no point did he deny making those statements. So I think that's pretty clear that he did not deny those. He also did not deny giving when I believe it was Miss Love leading, or I shouldn't say that. Miss Love was asking questions and getting into alleged facts that Demekion Garlington allegedly said. I believe that Mr. Zachary acknowledged telling the police about that as well, except he just said that, Garlington was a play. Garlington had given him the play was his ultimate explanation, but I don't believe he denied that either. So I think, sure, there's a lot of tangential points that perhaps a foundation was laid, but on the main points as it relates to Mr. Stillwell, at least, I don't believe that he denied making those statements, and therefore I don't believe it's appropriate to play the prior inconsistent statements because they are not inconsistent.
By the same token, Your Honor, he also did not deny having said in his previous interview that Mr. Kendrick had admitted to being involved in that murder. He said that it was a lie, but he did admit to having said that.
All right, I'll consider those over the break.
Your Honor.
One more, Your Honor.
Yes.
He admitted that Jeffrey Williams, that he said, Jeffrey Williams gave the vehicle to Shannon, allowed Shannon Nard to go up and drive as well as Mr. Copeland, and he was never even asked about giving Jeffrey Williams a gun, so it can't be inconsistent with being asked about that.
asking about giving Jeffrey Williams a gun. Give me a little bit.
And it's in his statement to the law.
About Zachary giving Jeffrey Williams a gun?
Yes. But he never was confronted about that.
Okay.
Your Honor, now that I think about it, he also acknowledged giving the statement to law enforcement about, well, yes, he acknowledged giving the statement to law enforcement about Mr. Copeland being at Big Boo's house and then saying, let's go, and then returning and learning that there was a price paid on the head. He acknowledged saying all that. He said he made it up, but he acknowledged saying all that. And he also acknowledged telling the police about what he observed at the Lil Wayne bus shooting when he was at Club Compound and cars leaving from there. So all those things were touched upon on his direct and acknowledged by the witness.
Your Honor,
Yes, ma'am.
saying that he told the police that and then saying, but it was a lie, makes the prior statement an inconsistent statement. Additionally, he said to the state, I was high on, or I was withdrawing from 3 or 4 different drugs, depending on what time he was talking about it. So his intent was to suggest to the jury any way he could that anything he said about and I specifically asked because anything he said about either of the 3 defendants in this case that he talked about, he denied were true. Everything.
Okay. Let's take our 10-minute break, which at this point will bring us back at 4:30.